Hi, and welcome to today's episode of the Property Pod. My name's Libby, and today I'm joined by Ed, who is a senior solicitor here at Wells, and he's going to speak to us about contentious probate and sort of what that means for you. So thanks so much for coming onto the podcast.
You're welcome.
Yeah. So tell me, Ed, what is contentious probate?
So when we use the phrase contentious probate, we're probably thinking of three main areas. The first is challenging the validity of will. The second area might be you've got a valid will, but someone's challenging whether they've had reasonable provision made for them in that will. And then the third area is probably disputes between beneficiaries or disputes between an executor of an estate and beneficiaries.
Okay, great. And who can contest a will?
So anyone can contest the validity of a will. If you think maybe a neighbour's made a will or their family had sort of put pressure on them to change a will, anyone can make that challenge. But if you're challenging for reasonable provision, so if someone's passed away and you feel you should have been left something, then only certain categories of people can actually make that challenge. The main category would be a spouse. So if your husband or wife died and they haven't left you anything, perhaps they've secretly left it all to their mistress or something like that, then the spouse can make a challenge, and the law says that they should receive from that estate the same as if they'd got divorced on the day they died. So the spouse is always in a very good position to claim reasonable provision. Children of the deceased can also make a claim, but they have to show that it's a claim for their maintenance. So if you're very financially secure, you've got your own house, your own income, if a parent passes away, you wouldn't be able to challenge that because you wouldn't need the inheritance for your maintenance. That's the key part there.
There's a lot to think about, I guess, and lots of different categories of stuff that you need to know. So, yeah. And how does the court decide if somebody has been left reasonable provision?
So it's not a straightforward question, or the answer isn't anyway. In this country, we have two competing laws. The first law says it's your money, your estate, you can do what you want with it. You can leave it all to the cat's home if you want to. That's not the same in every country. In France, you have to leave certain proportions to your children, and in Scotland as well, you have to leave certain amounts to your children.
Okay.
But we have this one law that says you can do what you want. But we then have the Inheritance Provision for Family Independence Act of 1975 that says certain people can challenge for reasonable provision, and those are obviously competing laws, because one says you can do what you want, and one says, well, okay, you've done what you want, but these people say they haven't had reasonable provision. So the courts look at a number of factors, and they do try and respect the person's wishes. So if they've made a will and they've given good reasons why they don't want perhaps one of their children to inherit, the courts would sort of weigh that up. But there's been lots of cases, different factors are taken into account, so it's not always obvious what the outcome of these claims will be.
I guess there's a lot to think about there, because, I mean, how would you know the difference between which one to go for, do you think? Just depends on sort of the circumstances and...
So the size of the estate is one of the factors. So if someone's died with £3 million and one of their children has been left nothing, and perhaps they're on state benefits, the court might think, well, if we gave them £200,000 for their maintenance, that would allow them to perhaps buy a flat, somewhere to live, give them some income, but wouldn't really deprive the other beneficiaries of much because of the size of the estate.
Okay, great. And how does somebody go about contesting a will?
So you don't need to instruct a solicitor, but it is a complicated area of law. If you think the will isn't valid, perhaps because you think your parent didn't have mental capacity, or perhaps you think somebody has persuaded them, lent on them to change their will, then one of the first things you should do is take out a caveat. You can go online. It's an administrative process. You don't have to put in any arguments or explanation. And that's a temporary pause on the estate. it says no one can get a grant of probate to deal with the estate whilst there's caveats in place. It lasts 6 months. You can renew it online at the end of that 6-month period. The problem is, once you've done that, if the person who wants to advance a will and get a grant of probate for a will, they do have powers where they can serve a special notice on you, called a warning off notice, to try and get you to remove the caveat. And if you insist the caveat is still valid, then it freezes the whole estate and you have to go to court to get it resolved. And if it turns out you were wrong to take out the caveat, then you'd normally be ordered to pay the costs of the estate. So it's taking out a caveat's good, but you do have to think carefully where that might lead.
Yeah, definitely. And how long does it take to contest a will?
So if it went all the way to a final hearing, a trial, it could take 2 to 3 years. Oh, wow. We've got some delays in the courts at the moment, some backlogs, but it can be quite a long process. The good news is probably 95, 96% of cases settle without going to that final hearing. And that might be because there's a weak claim, or someone makes a claim, but then there's a good explanation back and then they just drop the claim. Or it might be that the parties reach an agreement out of court and settle on that basis.
And how are claims settled by agreement?
So you can just exchange offers. So a solicitor might write to the other side and say, well, look, we don't accept you've got a valid claim, but the estate's prepared to offer X amount. And if that's accepted, then that's a binding agreement. If a dispute is quite involved and you're unable to reach an agreement like that, it's often a good idea to go to mediation. Mm-hmm. A mediator is an independent person, so not known really to either party. They're a trained mediator, they've passed qualifications, and you can go along a half day or a day, you're in different meeting rooms, and the mediator goes back and forth between the rooms, trying to help the parties reach agreement. It's not their job to decide anything. The mediator doesn't say you're right, they're wrong. It's just to facilitate the agreement. And in my experience, that they're often very successful, and you can have parties very much at loggerheads, but if you get together with a mediator, you find some common ground and some agreement. And one of the reasons mediation is a good idea is because it can take 3 years to go to court. Whereas if you meet up and resolve it, you've saved yourself a lot of legal costs and you've saved yourself all that time as well.
And who pays for the legal costs involved?
So I act for both sides. I act for people who are perhaps challenging an estate, but I also act for the trustees or the executors. The executors would normally get their costs paid from the estate. They'd have to act quite unreasonably in the eyes of a court not to have their costs paid by the estate. If you're bringing the challenge, the principle is normally that the loser pays the winner's costs. But you do have to be careful about offers. So if I brought a claim against an estate and the estate offered me £100,000, if I rejected that offer and went to court and I was awarded £80,000, I might think, well, I've won, I've got £80,000. But the other side can say, no, we'd offered you more money than you've just received from the court. You're actually the loser, and in that case the court would normally order the person who got the £80,000 to pay the other side's costs because they haven't beaten the offer that the other side made.
Oh, okay. And what range of legal fees might you expect to incur?
So again, it's difficult to say because you might send 2 or 3 letters and the claim settles. Most solicitors charge on the amount of time they spend dealing with a matter. So the quicker a claim settles, the less your legal costs. If a case went all the way to trial, then you might spend £50,000, £60,000, £70,000 more if it's a bigger case with more issues. But it's best to have a conversation at the outset with your clients, explain the costs. We often act for clients on a no-win, no-fee basis, or we also act on a no-win, less-fee basis. So you might pay a little bit as the claim progresses, and then you might pay a bit more if you're successful at the end of the case. As well as your solicitor's costs, you might have to pay court fees if you're actually issuing a claim. But if you haven't got any savings and you're on low income, you can be exempt from the court fees, and we're able to help clients get a court fee exemption.
Okay, great. Well, thanks so much for coming on today. It's been great to have you.
You're welcome.
And for all you guys at home, if you did enjoy this episode, please don't forget to like, share and subscribe, and we'll see you next week.